Good afternoon and welcome to today's webinar, Hot Property Management Issues, Topics, and Trends with attorney Denise Holliday and property manager extraordinary Mike Mumford. I'm Callie Waterhouse with the Arizona Association of Realtors. So for the first half of today's webinar with Denise Holliday, we're going to cover the Phoenix TPT Tax Increase, Section 8 tenants, accommodations versus modifications, assistive animals and abandonment. And then during Mike's presentation at the last half of the hour today, we're going to talk about the top 10 compliance violations property managers face. So I know that this sounds super exciting, and of course, what a hot topic property management is. So Denise Holliday has been engaged in landlord-tenant law since 1996. She's a Justice of the Peace pro tem since 2000, a Superior Court pro tem since 2002. She's president of the Arizona Landlord-Tenant Attorneys Association, as well as one of our wonderful AAR instructors. And Mike Mumford, boy, he comes in with years of property management experience. He's been involved in property management since 1996 when he joined Bennett Property Management, and he holds the National Association of Residential Property Managers RMP designation and the MPM designation. He is a NARPM certified instructor and teaches accounting classes and does audit compliance nationwide. Through all of Arizona as well, he teaches classes and various NARPM chapters, correct? Wonderful. Well, today's presentation is going to be about 45 minutes long, and then we'll have about 15 minutes of Q&A at the end. As always, today's webinar is being recorded and will be available on our website. So let's kick things off and welcome Denise.
Hi everyone. We're going to start talking right up front about the newest, hottest issue, which is the City of Phoenix increased their TPT tax. If you didn't know, you're probably not managing any properties in the City of Phoenix. Currently, the tax increase is up to 2.3% from 2.0%. What does that mean for property managers? Well, the law 331314E requires you to give the tenant and we notice the word 30 is not on that slide, a 30-day written notice. You're required to tell them that this increase is happening. We should have done it in December, before December 1st. However, the city did not have the information out to everyone. So they've agreed that they will not tag anybody on their audit for not doing it in the first month. However, they will start February 1st. So if you were not aware of this, you're probably going to have you or the owner pay out that additional tax amount, because you are still required to give your tenant the 30-day notice and then tell them what the increase is. The second issue we're having is the Section 8 tenants. What about increasing their percentage? Because there's a HAP contract. That's a special kind of contract between the Housing Assistance Program, the owner or the property manager, and the tenant. And the City of Phoenix Section 8 has said that they do believe that these Section 8 tenant contracts do not call for an increase. In fact, in the mail this morning, I received a letter from one of the housing coordinators for the City of Phoenix telling me that she believes I'm not correct, and that the Section 8 will not pay the additional tax and will not let you charge the tenant the additional tax. So stay tuned for this. This is something we're still going to have to continue to work on. Their position is that the contract says there shall be no increase to the owner during the term. Our position is that's correct, but it's not an increase to the owner. It's an increase to the City of Phoenix, which is the tax entity. So watch this. It's our position that they are not exempt from this new law, and we're going to have some good conversations in the next month with the City of Phoenix Section 8 program to all get on the same page. So our position is the tenants still owe it. City of Phoenix Section 8 believes they do not. So let's stay all in touch with each other. We'll send out the information as soon as we have a final verdict on that. The next session we're going to talk about is accommodations versus modifications. Frequently when I'm talking to a client, they'll say, well, the ADA says, and you need to know that the ADA is for public areas. If you're talking about housing, that's the fair housing laws. They're very similar to ADA, the Americans with Disabilities Act, but they're not identical. An accommodation and a modification are two different things. An accommodation is a change of a rule, change of a policy. something that you require or don't require. A modification, think about physically doing something to the property. Typically we think about like installing a ramp. But the difference between accommodation and modification are more significant because a modification typically involves money, the cost to do something. The landlord is not required to pay for the modification unless you're involved in a subsidized property, and that's some specialized rules. But they have to allow the tenant to complete the modification as long as it's reasonable. The tenant would have to pay for that, and they'd have to put it back in its original condition. Whether or not it's reasonable is very complicated. I'm going to encourage you to go to a fair housing class. We have one coming up here with the AAR, so we'd love to have you join us. We'll spend about 3 hours talking about this very complicated issue. As for an accommodation is when a tenant's asking for you to change a rule or a policy. The typical one we see is where a tenant who is receiving disability income asks you to change their rental due date from the 1st of the month to say the 3rd or the 4th, or maybe even later in the month if their disability check comes in later. That is considered to be a reasonable request, and there's a case in California that says you probably do have to grant that once you see the awards letter from the state. People frequently ask me, well, that doesn't make any sense because I have other tenants who get retirement income from an employer. Well, the federal government makes up the rules, and they're the ones that decided you have to grant it when it's a disability check from the federal government or from the state government. So if it was a private issue, that's regrettably not involved in this particular law. The other accommodation that we see a lot of requests is assistive animals. So the assistive animals issue is complicated because the ADA rules only have 2 species that are allowed to be an assistive animal, and that would be a dog or a miniature horse. Fair housing is different. There are no species restrictions. There are no breed restrictions, and there are no size restrictions. So if a tenant comes in and asks to have a pet that doesn't meet your other rules, for instance, your no pet policy, or you have a size restriction, or even maybe a breed restriction because your insurance carrier believes it's on the restricted breed list, they request to be allowed that particular animal, dog, cat, we've seen snakes, we even had an assistive chicken. If they comply with the other rules, you may have to grant it. And so we're going to walk through that procedure. But assistive animals are different than potentially just service animals. The category is service, assistive, therapy, companion. All of those animals, if they meet the other criteria, do in fact qualify. So the question I frequently hear from clients is, well, what can I ask for? Because the tenant told me it's a service dog. And I asked them for something from their doctor, and they told me I don't have the right to know anything. They can't ask me for any documentation. And that's not true. HUD, which is the agency that really deals with all of our special accommodation requests and modification requests, they put out some really good memorandums. And one of those memorandums specifically says that you're allowed to ask for verification from a medical provider. That's a little complicated because what's a medical provider? There's no definition. It might be a school nurse. It might be a counselor. But documentation from a medical provider that the tenant is disabled under federal law, that disability is interferes with one or more life activities, but more importantly, that the tenant needs this animal to perform a service, a task, or alleviate a symptom. You have the right to request that information in writing. However, remember, if a tenant is impaired, so they can't put it in writing, if they have a disability involves being able to write or being able to see, then the accommodation that you're granting is not requiring it be put in writing. But otherwise, you ask for this documentation in writing. A certificate from the website that says their dog is registered as a service animal is irrelevant. There is no specific documentation for fair housing. There is for ADA, but not for fair housing. So if you have any questions, we have some great forms on our website. If you haven't been there before, our website is free. It is drevictor.com, all that's spelled out. It's also on the information at the end of our class today. But there's 2 great forms. One is where the tenant asks you for specific accommodation or modification requests, specifically what they want you to do or grant. And the second one is the form that the medical provider fills out that validates all of that information. Finally, you really need to use a good lease. I can tell you that the AAR lease is fantastic. It's vetted by lots of professionals. Lots of judges see it and know that they don't have to read every single line. So really the key is make sure that you use a really good lease to start out with. And that lease, actually the new AAR lease, has a special section where it reminds you in the application that you should ask if there is a service animal, but you're not required or not allowed to take in any pet fee, pet deposit, or have any special restrictions if it's a service animal. But also look at some good addenda. There are some great ones out there. Be careful. If you think of something brilliant, you might want to talk to an attorney, because sometimes whatever you've magically thought of might be a prohibited provision. 331315 is a special law in the Landlord-Tenant Act that says if you add a prohibited provision, you may have to now pay your tenant free rent just for including that particular special clause. Once again, this is our website on the screen. There's a number of suggested phrases and clause on that form. And an example of a really good fair housing or a special form would be the jury trial waiver. It is not included in the AAR lease. And we think it's a really good idea because juries frequently look at landlords as having really deep pockets with lots of insurance and may not necessarily rule on what the law says about a particular issue because they feel bad for someone. So a jury trial waiver can cost your owner a lot of money by not having it. An average jury trial is at least $5,000. An average eviction is something much closer to less than $200. So it's a huge difference. Another real common clause and phrase that we don't see in a lot of leases is the in case of death, disability, or incarceration form. The statute's 331314, and specifically it says the landlord has the right to ask, what should I do with your stuff if you pass away? The AAR application has a place where you can ask that. It doesn't explain in detail really what's involved, so an actual addendum that gives the tenant more information about be careful who you put here, because this is the person who's going to get your parakeet. You really need to think about that ahead of time and make sure the tenant understands what they're signing. Another form that's really fantastic is a special clause that says in the event that you leave behind your stuff because you just didn't think it was that important, I have the right, if I reasonably believe that it has no value, that I can throw it away. Otherwise, if the abandonment statute is now triggered, that particular statute says you have to store it for 10 days. You have to send a certified letter, return receipt requested, to that tenant's address and any alternative address that you know of where this stuff is kept. And this is a great picture because you believe the couch looked like the bottom picture. Tenant believed it looked like the top picture. And unless you have verification of what it is you're actually tossing and why you believed reasonably that it had no value, you're going to be having a very expensive fight with your tenant. So if you included this magic language, you can find that language in a lot of different places, once again on our website also. Be careful about that abandonment process. That clause that says we can throw it away in the event that we believe it has no value does not apply after the constable has come and locked someone out. That's a rude process. They only have about 5 minutes to get their items out. And so that law requires you to store their stuff for 21 days and to send the forms the exact same way. So be careful. Even if you have the abandonment clause, which is fabulous, you're not able to use that clause if you are involved in an eviction with the writ of restitution. 331368 is the statute that deals with writs of restitution and what to do with tenant stuff. 331370 is the abandonment statute. And like I said, while they have a lot in common, but they parallel each other, they are not the same, and how you deal with their stuff is not identical. And then what about pets left behind? I mean, that frequently happens where the cat hides underneath the bed or constable shows up and everyone's at work, and so they complete the lockout. What do you do with the dogs, the cats, the horses? Well, the law says you are required to store them for 21 days if it's a writ of restitution and 10 days if it's an abandonment. I don't know about you, but most animals that have been stored don't typically survive the storage process. So we would encourage you to take other matters in your hand and find someone who can store the animal. Typically we call that boarding. But it could be done really any place, anywhere, but you are required to feed and care for the animal for that entire period. 21 if it's an eviction and 10 days if it's an abandonment. We suggest that you hook up with, there's a really great realtor association group called, I think it's called Lost My Home, and a bunch of realtors got together, put together this organization, and they work with no-kill shelters who understand that they're required to store the animals for certain periods of time, and that the tenant cannot get the animal back until they pay the cost to board the animal. So, Mike, I think you are touching some other really scary points.
Before we continue on, I just have a couple of questions here. Let's talk about TPT for just a second, and can you clarify what that is attached to? Is it short-term rentals only? What does that tax get taxed onto?
Okay, the TPT tax is very complicated. And actually, if you go to the city of Phoenix, just go to their website, they have a list of every single thing the TPT tax touches. And so each city, or most cities in Arizona, charge a TPT tax. They don't all charge it on the same things. Some TPTs are charged on late fees, and other cities do not. Some cities say if you have one or less properties, you don't have to pay any TPT tax, and some charge it on the very first one. So it's important that if you're doing business in any city, that you go directly to the city website and print it off. So that in the event you get audited, you can show, well, this is what I used to determine how I charged that tax. So yes, it is on vacation rentals. It is also on regular rentals. It's on lots of things, including things that have nothing to do with real estate. So it's very important that you go and read the special tax laws because they're very complicated and not all cities agree. Mike will spend some time a little bit later when he's talking about our consolidation efforts and using the software, which is not working exactly, but he will spend some time talking about what those issues are and giving you some guidance how to navigate that particular new system when it goes into place next year.
Yeah, I'll go ahead and touch on that right now while we're in there. One rule of thumb to use is any money that goes from the tenant to the owner is taxable, regardless of what you call it. Almost all cities are falling under that. There's a thing called the Model City Code that most cities have adopted. They're getting more similar in how they're handling this stuff as we move to the new process. But any money that comes in from the tenant that goes to the owner is taxed in those cities, including but not limited to pet fees that are non-refundable pet fees, security deposits when they're released, any utility payments, any CAN payments, any payment that goes from the tenant to the owner is taxed.
And the basic philosophy is that it's income to an owner. So if it was just paying an owner back for something that they were actually billed out, it's not like on your management fees. It would be anything that's called income to an owner. And once again, really work with your tax professional because this is a complicated area, and if you do it wrong, there are pretty significant fines.
Yeah, and on the exemptions on that, there is a casual exemption from most cities. It's usually between 1 and 4 units if you're self-managing. If you manage through a property management company, the property management company manages probably more than 4 units, and so you're going to be taxed. So an owner that owned 1 home in the city of Phoenix would have a casual exemption. An owner that owns 1 home in the city of Phoenix that has it professionally managed owes the tax. So again, it is very complicated. Make sure that you go to the city websites and you look at that and you know what you're doing. But that casual exemption does not come into place if it's professionally managed.
All right, so we're going to move on to top 10 audit violations.
All right, and so the top 10 audit violations, this list actually came directly from the Arizona Department of Real Estate's website. They put out bulletins once a quarter, and I would highly recommend that you do subscribe to those and see what the current trends are. The top 10 came out in November of 2014, and I talked to the commissioner and some of the auditors towards the end of last year, and they said they're primarily the same. Has not changed a lot for the violations. The sales changed a little bit. For property management, it hasn't changed much at all. So trust account deficiencies is one of the big ones. I don't know if you realize, if you pay attention to those, over the last 3.5 years, there's been over $6 million missing out of property management trust accounts. It's a huge number. It's a huge problem. Some of it has been just willful theft from the broker owner. Others have been discrepancies and people just not understanding quite how to do that. And we're going to go over that a little further into the webinar here. Trust accounts not balanced, unexplained overages. If you're not doing the proper reconciliations and not tracking through a good property management accounting software, you can have overages, and that is also a violation. If you have extra money in the account, that's not okay. It's not as it's treated the same as a violation on an underage. So make sure that you are taking care of that. You're taking the money out. You cannot commingle your funds with their funds. I hear this next one a lot: failure to perform and maintain trust account reconciliations. Most people do a bank account reconciliation. There are a few that don't on a regular basis. You're required to do it every 30 days, once a month. But they don't do a three-way reconciliation, or if they do a three-way reconciliation, they are not maintaining the records, printing the reports, saving a digital copy of what they need to do. So failure to maintain that, if they find that there is any overage or underage, any kind of deficiency, and you don't have the records proving that you've been doing the proper reconciliation, that's going to get you in more trouble. Negative owner balances using to be offset broker liabilities. You can't have any negative owner balances. So you can't use the owner money to pay for any of your expenses. That's a huge no-no, and it's one of the most common violations. Trust accounts that are not clearly designated as such. There is specific wording that you have to have on your trust accounts. They have to be designated as a trust account, not just in the title on the bank statement or in the mailing address. It needs to be on the signature card. And why is that so important? One of the reasons, if the government comes in to seize a bank account, if the bank goes to freeze your assets based on direction from a government entity, some type of problem, they're going to go look at the signature card and how the bank account was set up. And if it's not clearly designated as a brokerage account, a fiduciary account, a trust account, they can freeze those funds. I know of a property management company up in northern Arizona where it was not designated properly, and the brokerage has their account frozen due to a tax liability that wasn't paid for a separate company. The broker happened to be an owner of a separate LLC, and that LLC didn't pay its payroll taxes. And when they came in to seize the accounts, they seized the account not only of the LLC, but also of the property management company. The account got unfrozen and got taken care of, but it was a huge hassle. And for several weeks, they weren't able to write any checks to pay vendors, owners, or tenants. It's a huge deal. So make sure that they are designated properly. Another issue, online banking websites inappropriately being used as off-site storage. You're required to keep copies of canceled checks, copies of your bank statement, copies of your general ledgers, check registers, all of that. We'll go over those record-keeping things on site. They can't be stored online at Wells Fargo, Bank of America. If you have to access the bank's website in order to get a copy of a check, that is not considered proper record keeping. You have to have it digital and available, or a paper copy available in your office. You can't log on off-site to go get that. PM agreements failing to comply with required clauses. The non-assignment clause is a big one that's missing. Another one that they've had issues with and they're auditing fairly strongly is security deposits. The security deposit, it has to match what's in the management agreement, has to match the lease. If the owner is holding the deposit, the management agreement has to say that and the lease has to say that. If the property management company is holding it, again, those two have to match. So there are several things that required clauses that are in there. Look up ARS 32-2173. There's a list of several things that have to be in there. They shall be in the agreement. And there are several things in there that may be in the agreement. Things that may be in the agreement, auto renew clauses, those types of things. Speaking of auto renew, that clause may be in there. You can do that, but you must give the owner 30 days written notice that you intend to renew the management agreement. If you don't give that notice, then the management agreement does not properly renew if the owner didn't want it to. They have some recourse on that. A lot of companies have that auto renew clause in there, but the tracking of that and the sending out of the 30-day notice is either not being kept and not being properly maintained. That's a big audit issue now. So if you have that clause and you utilize it, make sure that you do have a written record of when you send that out, at least 30 days in advance. Remember to allow time for mailing. You can't mail something on the 31st of the month and have it be proper notice. It has to be mailed out in time. And send that out so you auto renew. This one gets me. General lack of understanding of accounting basics. I know a lot of people started property management companies. They were a salesperson doing real estate and kind of fell into it and are doing their own books. And that has been a huge problem. It's causing deficiencies and other errors. So make sure that you're using good accounting software and that you hire a professional to do your books for you. It's a huge deal. And the department is not being very lenient on missing money. This last one, changing property management accountware. This is talking about online software. If you have online software that all of your stuff is stored in the cloud somewhere and you switch software vendors, you may no longer have access to look at those records. You're required to keep records for 3 years. You can't store records online. That's allowed through cloud systems and that, but you have to continue to have access. I've heard some of the auditors have an issue when they switched from a property management software to a different property management software. The old software company printed out Excel spreadsheets and lists of all of those so they have a paper copy. You can't regenerate an owner statement. You can't regenerate some of the other ledgers that you need. So make sure that you have those. If you switch, you need to maintain access through some method to be able to be in compliance. So, and this is, again, straight from the Arizona Department of Real Estate. So if you notice a common theme in these, 7 of the top 10 regard accounting. It's about money in the bank and missing over $6 million. Those are the ones that they found. There's probably other money missing out there that they haven't come across yet. And typically when they find a company that's deficient and doesn't have the money, they come in and the bank account has actually $0 in the account. They've taken it all. There was in the bulletin that last came out, they came to do an audit, they came on site, all of the furniture was gone, all of the equipment was gone, and the broker said, yep, I just took the money and just took it all. Hundreds of thousands of dollars, just took all the money. So it's a huge deal. That's why they're concerned about it. Make sure that you're following through and you're auditing your books. Do internal audits, get somebody else to come in, make sure that it's right, because they will shut you down and it's not fun. So, good news. The department has recognized that this is a problem and they have spent a lot of money trying to promote ways to get better. They're promoting education. They have talked to me about writing some classes and getting out there and doing some trust accounting training for property managers to make it easier and better to comply so that you do know what you're supposed to be doing. On the website, they've got some great materials, and this is fairly new. It's been out there for about a year or so, but most people I talk to in the property management industry aren't aware that these tools are out there and available. So there's an audit packet. There are very specific instructions on how to reconcile your bank account, instructions, forms, samples, spreadsheets, step by step, telling you exactly what they want to see when they go through there. There's a broker audit declaration form. There's a trust activity notification form. The broker audit declaration form is when you renew your license. All of those questions that you answer, yes, no, not applicable. When they come do your audit, they're going to pull out the last form that you did, and they're going to go through and see, did you answer truthfully in those? And if you did not, you're potentially going to be in trouble. So pull up that form now and take a look at it and make sure that you're in compliance. It's a great form to use as a checklist for what they're going to ask you and what they need. The PM audit packet is phenomenal. There's an audit checklist that just goes step by step that tells you exactly what they're going to ask for. You should not be surprised by anything that they ask for. So that information is out there, and it's a great tool. I highly recommend you go in there. Let's talk a little bit about trust compliance. Account designation, ARS 322151. is the statute that tells you how to name your bank account to make sure that it's properly named. One of the auditors is an ex-IRS auditor, and that suggestion was real estate brokerage trust account. For naming your account, that will help the IRS identify that that's not your money, that that's somebody else's money. Might be something you want to look at. And make sure if you've changed banks that your account transferred over correctly. We've had some banks bought out by other banks. When the account transferred over, it actually did not transfer over as a trust account. It just transferred over as a regular checking account. I know of multiple property management companies, after taking a class, went in to check to get a copy of the signature card, and the signature card just was a regular old business checking account, not a trust account. So if you've had any changes, make sure you do that. Make sure that you have the copy of the signature card on hand. Let's talk a minute about permissible signers, broker, licensees. Unlicensed employees are allowed to be signers on a property management trust account as long as they are in the direct employ of the broker. If you have a CPA who is an independent contractor, not a full-time employee or part-time employee of the broker, they cannot be a signer on the account. But if you have a full-time bookkeeper who is your direct employee, that person could be a signer on the trust account. That's a business decision about who you want to sign on the account, who you want to have access to that, to make sure that you guys are in compliance. Brokerage funds allowed to be $3,000. That changed. It used to be $500 a couple of years ago. Hopefully you all know that you can keep up to $3,000 in the account. A couple of issues on that. It's, in my opinion, a good idea as a business decision to leave some of your money in the account to cover unintended shortages, bank fees, checks cleared for the wrong amount, those types of things. If you have a little bit of money in the account, those will go against your money, not against another owner's money, causing some commingling. So it's a good idea to have some in there, but be cautious. You do need to remove anything excess of $3,000 or whatever your limit is at least every 30 days. You're required to take your money out every 30 days. So if you have fees building up in the account, that's fine, you can do that. But once every 30 days, you need to take that money out of there. As far as CDs, interest-bearing accounts, savings accounts, those types of things, you're allowed to do that. If you disclose to the owner who gets the interest, usually the management company retains the interest to offset costs, which is fine, it's legal. You have to disclose it in the management agreement, and you have to sweep those funds at least once a year. You can't leave that money sit and grow forever. At least once a year, you have to take that out of there and take that back to take the income out of there for the account. Another confusing item, if the broker or any of the licensees or employees of the company own rental properties, the funds for those properties cannot be in the main trust account. We'll say that again. If the broker owns a rental house, the money for that rental house cannot be in the main trust account. And here's the reasoning behind that. That's considered commingling. In a trust account, you are not allowed to have your money commingled with their money. If it's your rental property or a licensee's rental property, that's your money. The licensee is an extension of you. So that's your money that's in there. That cannot be in the main trust account. You would have to have a separate trust account if those properties are run through the management company. If you have an agent that's managing their own properties not through the company, that money does not have to be in a trust account. I would recommend that you do put it in a trust account, but the department says you don't have to have that in a trust account. So that goes. That also goes for broker, licensees, agents, employees, and their family. The commissioner has defined family for that specific instance as parents, grandparents, siblings, whether by blood or by marriage, children and grandchildren. So that also applies to all of them. So make sure if you do have that situation, you do have a separate trust account, and there are some rules about who can sign on that trust account. Rent deposits, in sales, you have to put the money into the account immediately. In property management, you have up to 3 days to deposit the money to the bank. The only exception to that is disputed funds. If a tenant owes you $1,000 and they drop off a $10 money order, you don't have to take the $10 money order. You have up to 3 days to deposit it in the bank or to dispute it. Now, you do have to dispute that and let the tenant know within a reasonable amount of time that you're not accepting their payment. Either let them know, put them on notice, mail it back to them, whatever your company policy is, but you should have a policy in place on how to deal with disputed funds. Three-way reconciliation, this is one that's a huge item that's missing from lots of companies. Again, most people balance their bank statement to their check register and they say, oh, I'm good. Well, you don't really know that you have all the money you're supposed to have unless you're doing a three-way reconciliation. A standard three-way reconciliation, after you balance the bank statement and get an adjusted amount, you need to add up the client ledgers, which is all of the tenant money, all of the owner money, and all of the brokerage money. And all of those items have to equal in order for you to be in true balance. If you manage 10 properties and each owner had $1,000 and you got a bill for an AC, for a brand new AC for $4,000, well, you have $10,000 in the bank, you can write a check for $4,000 and it will clear the bank. And you can balance your bank statement and your bank statement will balance saying you have $6,000, but do you have all the money you should have? No. One owner is negative $3,000 and that's not okay. The only way to check that is to do a true three-way reconciliation. Again, very specific instructions available on the ADRE site. Some common trust account errors. Commingling funds, we just talked about that. Commingling funds is where you use one person's funds to pay another person's obligations. You shouldn't have any negative owner balances. You can't use owner A's money to pay owner B's bills or your bills. Liability account issues is another huge one. We're talking about taxes. As taxes accumulate in the account, you need to make sure if you have a liability account for taxes that you're balancing each of those individual ledgers as well. I see posting date discrepancies quite a bit out there. Money will come in, they'll do a new lease, and the money will be due on the 3rd of next month. The money will actually be received on the 27th or the 28th of the previous month, and the property manager's bookkeeper will post that as of the 3rd of next month. That causes some real issues. So make sure that you don't lie to the computer. Bad things happen. We all remember 2001 Space Odyssey with HAL, right? So don't lie to the computer. If you post it, if you take it to the bank on the 28th, tell the computer you took it to the bank on the 28th. That's fine. Seeing an issue with old uncleared transactions. We all know we have those tenant security deposit refunds where we send out a check for $57 and they just don't cash it. You have to deal with that. You just can't let it sit in the trust account. I've been to a few other companies and seen where they have uncleared checks from 4 years ago. And that's not okay. That's going to count against you. And the auditors will tend to ignore those, which will throw you out of balance. So anything more than 6 months or a year old, you have to deal with it. There's several different ways to deal with it. You should escheat it to the state. You can't just take the money. You can't just leave it sit there. You need to deal with it. Data entry errors, unintended shortages, very common. And if you're not doing your proper reconciliations, you're not going to find those. You're going to have those issues and you won't realize that you've had them. And trying to deal with those a year and a half later is very, very difficult. Doing a forensic audit from quite a while ago is tough. Let's talk about record keeping for a moment. Financial records you are required to keep for 3 years. And here's a list of everything that you have to keep for 3 years. So it's quite an extensive list. The bank statements, deposit slips, and these are all records that you have to have in your office, either digital or in paper form. You can't log on somewhere else to get these. They have to be in your office. A little more on record keeping. Management agreements are 5 years. Those are employment agreements. Residential leases are 1 year. Applications are 1 year. Be careful on applications. The ADRE requirement is 1 year, but your credit agency may require you to keep them up to 5 years. And fair housing may have an issue. If they come in, you ever get an audit from fair housing, which is not fun, believe me. You don't want them knocking on your door. They may come in and say, we want to look at your denied applications for the last 5 years. We want to look at all of your approved applications for the last 5 years. So make sure that you talk to whoever you're pulling your credit and criminal from and follow their guidelines for you. They're the ones that are pulling that for you, and you need to make sure that you follow their guidelines on that.
And Mike, real quick on that, on the residential leases, a tenant can sue you for up to 5 years. So if they can sue you that long, you might want to keep those records that long also.
Absolutely. And IRS records for financial records are 7 years. So if your owner gets an IRS audit and comes to you for copies of invoices and that, and you've only kept them for 3 years and they're looking for something 6, 7 years old, you may want to keep them for longer than that too. We're going over the ADRE requirements. It's a business decision. You need to talk to your insurance company and make a plan with that, and talk to an attorney on that. Some say that you should only keep it as long as you're required to keep it, then you have no liability for anything after that. I kind of disagree with that. I think you should keep it for up to 7 years, for as long as it's going to be helpful for your owner. You're required to be a fiduciary for them and to keep those. And so if your owner needs help from that, even after you stop managing for them, you need to make sure that that responsibility does carry on and you have those records available. All right, a little more on TPT tax changes. The governor's office, actually the state, passed a law several years ago for TPT simplification. And actually, the House bill was meant to make it easier to do business in the state of Arizona, was the gist of the law and the intent of the law. For TPT taxes, it has not simplified anything and has made things much more complicated. What will end up happening eventually, we don't know when, the Arizona Department of Revenue will be the one point of collection for all TPT taxes, will be the one system to use, the one auditor, the one point of contact. So instead of paying some to the Department of Revenue and some to individual cities, everything will be paid to the Department of Revenue. Their system is a custom system and is antiquated and is having difficulty reporting the information necessary back to the cities. So there has been some issues there. They're working on them to get them resolved. The intent is, a few years from now, to each owner, possibly each unit, will have its own tax license. You will report those to the department. They will integrate with software, so you will be able to report those via CSV file, Excel file, something like that, along with one check, which will make it much easier for property managers. Until that comes, it's very difficult. We've got some conflicting information. It continues to change. The last word that we have from them is to continue paying as you have been paying, continue paying the individual cities, continue to renew those licenses until they come up with a final version of what we're going to do. Hopefully that helped.
Wow. I wish you folks could see Denise and Mike when they talk about TPT and property management. I think Mike is just beaming over here. He has such a passion for property management. It's really, really kind of cool. All right, ready for some questions? What if you have written permission from the tenant to dispose of any remaining belongings in a move-out or an eviction? Any special issues to note?
As long as you are taking that written permission at the time it's happening, that's fine. If you take it at the beginning of the lease, you're taking away one of their rights, and as such, it's a prohibited provision, and you may end up owing them about 2 months free rent. So at the time that it's happening, when they say, hey, I've got everything else I want out, you can toss everything else. Absolutely get that in writing. So if it's a phone call, tell them I'm going to keep charging you until I get something in writing.
Great. Okay. And then as far as TPT, are we not obligated to remit the 2.3% for January?
That is a great question. What they have said is if you collect it, that's fabulous because you're required to collect it. But if you don't collect it, we're not going to punish you. They can't really punish us because the city law is inferior to the state law. The state law says you have to give the tenant a written 30-day notice ahead of time. So what they've told us is they are not going to impose any kind of penalty for anybody who didn't collect it in the month of January.
But starting in February?
Starting in February, they're going to require that you pay it even if you just now found out about this. And if you don't get the notice to your tenant until now, you're going to pay, or your owner is going to pay that tax.
And does income to owner include maintenance that is then reimbursed by the tenant?
Yes. The cities have come down and said, yes, that is taxable activity. Each city is a little different. Like Denise said, you need to check with the city. But in talking with the auditors, the League of Cities, and several of the different cities, if you collect maintenance or maintenance reimbursement from a tenant, that's taxable income.
Very good. All right, so I'm going to read this one verbatim. So, you know, with reasonable accommodation, if an AC unit heater is showing a 6 to 7 degree less than the thermostat, would this have to be fixed under a reasonable accommodation?
Okay, that's a good question. They're really separate subjects. You are required to maintain a reasonable amount of heating and cooling. Every city has a different rule on that. For instance, here in Phoenix, Phoenix will say that you have to have it cooled, I think it's to 84 or 86 degrees.
Mm-hmm.
There is no such rule in Flagstaff because they don't even have air conditioning units in a lot of rentals in Flagstaff. They have a much different law about heating. So if the unit is putting out air that is not the same temperature as the thermostat, is that a material breach of the landlord's obligation? No, because you're required to provide a reasonable amount of heating and cooling. The heating and cooling is one thing. Whether or not you can know exactly what the temperature is more of a monitoring system, and that's not something that's governed. A tenant will still complain and you still may have an issue, so it's better to get it fixed, but that has nothing to do with what we call a reasonable accommodation or modification, because that's specifically dealing with somebody who has a disability that impacts their ability to live on the property.
And what if a prospective tenant says they will pay a deposit for an assistive animal as a good gesture?
That is a fabulous question. Don't do it. Even if they offer to pay a deposit, you are not allowed to accept a deposit. Same thing with Section 8. If you have Section 8 tenant and they offer to pay more, you are not allowed to collect more because the HAP contract governs and you're not allowed to change that. So if a tenant who has a service animal says, oh, I'm not going to give you the documentation, I'll just pay the deposit, well, there is no documentation that is a service animal, take the deposit. But once you receive that documentation, you can't choose to allow the tenant to pay you a pet deposit as a good faith option. They're still responsible for all the damages to the property, but you can't charge a pet deposit or pet rent, even if it's offered once you receive the documentation that it is in fact a service animal.
Good point. And I would also say with Section 8, not just a deposit, but extra rent. You cannot charge if the tenant says, hey, I'll pay you $50 on the side in order to rent this place. Don't do that. You're asking for trouble.
And actually would be anything to do with Section 8. If they want to add an extra occupant, don't tell Section 8, I have my uncle living here, I'll just pay you extra, is not acceptable. There can be no deviations from the Section 8 HAP contract or from your lease, not one single deviation.
And part of the problem with that too is Section 8, they may start abating the rent and you may not be able to evict the tenant. So you may be really harming your owner not being able to collect rent for a certain period of time until that thing is rectified. So if they have an extra occupant there, you can't evict them depending on what it is in the situation. Each situation is a little bit different. But you may cause your owner to have rent abated by a decision that you made to vary from the lease. So just bad news, don't do it.
And we have several questions regarding the PMA renewal notice. Can this be emailed? Does it have to be snail mail? Does it have to be certified? Can it be a combination of both? What's the best way to handle that?
Well, the law is pretty clear on notice in the state of Arizona. It's either hand delivered or certified mail. They're changing a bit regarding DocuSign and email, allowing that to come through. The best thing to do is to make sure that you have written communication with your owner. I would say that if you have an email response from your owner that is printed in the file, that's probably going to be good enough to suffice for notice to the owner. If you email them something and you don't get a response, you're probably not going to be covered on that. You don't know whether they ever got it or didn't get it, or how that went through. So until you have either hand delivered or certified mailed it, if you don't have a physical response from them, even if you have a phone call, and any phone call that you get for notice from an owner, it's always best to follow it up with an email. Per our conversation today, this is how I view the facts. Make sure you follow up all your phone calls with that so you have a written trail of what you did. Just make sure that you do it in enough time and you're dating the letters that go out or the emails that go out for your owners.
And I can tell you that the ADRE rule is just not clear. The written documentation for landlord tenant is very, very clear. And so if you didn't send out certified, you sent it out regular mail, it would be the owners would have to come and contest that he didn't receive it. So if you kept some kind of other recording of anything you sent regular mail, like some people keep a list of all mailings where they take a copy of the front envelope with the date postage stamp on it, it would be something that you can prove that was actually sent.
Would it be commingling if we, and that would be the property manager, deposit a personal check into the account to pay an owner for a repair error? Example, they have a warranty company and a normal vendor is sent. There's a $200 difference between the trip fee and the actual charge. So a check was cut and put into their account to show a positive balance.
I don't believe so. I usually, you want the money to flow from the brokerage operating account to the trust account. Typically, money from the trust account should not go directly to licensees or from licensees. So if the licensee were to pay the brokerage, then the brokerage was to deposit a check into the owner's account. That's probably the best way to handle it, the cleanest way to handle it. The other would probably be allowed, but it's going to raise some red flags, and the least amount of red flags you can raise, the better. It is absolutely fine to pay an owner back for a mistake. If it's under home warranty and it would have been $59 and the bill came in at $300 and you pay the balance, that's absolutely fine. Write a check for that to your broker, have your broker put the money back into the owner's account, into the trust account, and make the owner whole again. Yeah, that's fine.
Yeah, absolutely agree.
So Mike, you mentioned just briefly, what is the correct way to name an account for banking purposes for the trust? What's the correct way to name that?
There's 5 or 6 different ways to name that. Trust account, fiduciary account, real estate brokerage trust account. They're in ARS 322151, I believe, or 2153 to name the account. And I don't remember the specific wording on all of those. Again, the auditors from the department have recommended that you use the wording real estate brokerage trust account. That's from the top investigator, and that's what we use.
Okay, it looks like we need a little bit of clarification. So we said earlier, I believe, Mike, when you were speaking, to pay the cities as we have for the taxes, ADR is saying that they are the single payer as of January 1st and to pay only them.
I believe they've changed what the website says. I talked to them not too long ago, and they have I believe they've updated the website. They're not saying that anymore. That was the intent 5-6 months ago. They were pushing really hard to get that done, but they've missed the mark.
I think you have to realize the government's trying to figure out how to consolidate and streamline, which typically is very, very complicated for a long period of time, and then it's eventually much better. And we're just in that process. It's taken a lot longer for them to be able to create the system and put it in place than what they intended. So continue to watch that website because it will tell you exactly what you need to do. But until you have a clear directive, follow it the regular way. If you're doing it the regular way, you're not going to be in trouble. So I can tell you that's the best way to proceed.
The individual city websites have been updated much faster than the Department of Revenue's website. So if you manage properties in Chandler, Phoenix, any of the other cities that collect taxes, check with them first. Probably the most up-to-date information.
So the next question is, can we charge tax to the tenant on all reimbursed income to the owner to cover the TPT tax? Can you charge tax to the tenant on reimbursed income to owner to cover TPT tax?
So I want to make sure that I understand the question correctly. Tenant clogs up the drain or the garbage disposal. You send the maintenance guy out there and he says there was a fork in the garbage disposal. They caused this. It was $100 to clear that. Absolutely. You charge the tenant $100 plus tax to cover the income to the owner for that. Yep, that's fine.
Okay. If tenant has given you documentation for their service animal that is more than a year old, can you ask them to submit an updated form from their medical provider?
That's not a very good idea because if you're blind, you're really blind and it doesn't stop in a year. So if you're disabled, you're going to be continuing to be disabled. That's what the type of federal disability issue is. It's not a temporary condition. So if you fell down and broke your leg, that you do not qualify as disabled under federal law. So I could tell you it's not a good idea. There's been a group of people that have wondered, if you live in Arizona, you've always lived in Arizona, is it reasonable to have a doctor that's on the internet fill out the forms when they've never seen you and they've never provided any medical care for you? That is a great question, but no one has taken that case yet. If you would like to be the test issue and refuse it, let me know. I'd gladly take your case. It will be very expensive for the first case because no one's really sure what that answer is going to be.
Excellent. So just for clarification, every communication to a tenant, does it need to be certified?
It depends if it's a notice. Notice is defined by statute 33-13-13. So if you're required to give the tenant a notice of something, non-payment of rent, notify them of a breach of a lease term, notify them that you're coming in to enter the property, all of the notice requirements have to be either put in their hand or sent certified or registered mail. There are other times you contact a tenant that is not required under the notice. For instance, a security deposit. The security deposit letter has to be sent within 14 business days, but that statute does not say that you have to send it under the notice provision. It's better to send it certified mail, but that particular statute says regular mail. So it depends on what you're sending and what the tenant is required to receive. If you are sending them notification of a tax increase, that technically has to be sent certified mail. If it's other types of notices, some notices have to be sent certified mail, return receipt requested, and that's under the abandonment notice and the location of abandoned property notice and the 21-day letter following a writ of restitution notice. But those are the only notices that have an additional time frame and notification process.
I think one of the things on that you need to think about is if you do end up in court, how do you prove that you notified the tenant? That's the big thing. And if you're just sending an email, just making a phone call, leaving a voicemail, don't get any communication back from the tenant, you're leaving yourself open. You need to make sure that you're covered. With certified mail, you can prove that you certified mailed and when you certified mailed it. So those are the issues you need to think about.
And the law actually says that if you send it certified mail and the tenant doesn't pick it up, it's deemed received. That's the key. So a lot of people are wanting to use other alternative electronic forms of communication, text messages and emails. We're not saying you can't do that. We're saying you have no proof that they actually received it. And so if they respond to your email or respond to your text and you can print it off, terrific. But other than that, the only one that's deemed received is when it's sent certified or registered mail.
So next question on keeping accounting records. If you're with a brokerage and you switch, we talked about accounting softwares, you go from one accounting software to the other. How would you keep records from the past that you no longer have access to?
The broker is required to keep the record. So if you're switching, those accounts would belong to the broker. That broker would be required to maintain all of those records. And so if you switch brokerages, the old broker is required to keep that. As far as softwares, I really don't know. The last time the auditors, I talked to them, they said they've identified over 50 different property management accounting softwares out there. So the way that they allow that, whether they allow access, don't allow access, whether you can print it off, not print it off, I truly don't know how they each do it. I'm just telling you that that's an audit violation that you need to consider when moving from property management accounting softwares to another one. Talk to your old software company and see, how do I access my information? What can I do? Do you need to, have a digital copy of all your owner statements, all your check registers, all of that? You still need to comply. So it's just something that people are missing on a regular basis. So pay attention to it.
Okay, and going back to the assistive animals, does the disability have to be federally recognized? I thought anxiety qualified for assisted animals, but I don't think anxiety is a federally recognized disability.
Actually, that is one of, any of the mental health disabilities are all recognized. And so the list continues to grow. And the most important thing is don't be the doctor. Don't be the person who makes the decision. If a physician or medical provider says they're disabled under federal law because I said they are, you don't have the right to know what the disability is. You just have the right to know that they are recognized as disabled under federal law according to this particular provider, and that they need this animal to provide a service or task. There's another aspect of that the disability interferes with one or more life activities. I can tell you that every service provider will tell their patient that one or more life activities is impacted. So real simply, have them fill out the forms. Once you get the forms, in the discussion, unless you want to take the risk of now being involved in the lawsuit.
So if a partial payment is received and you notify the tenant that it's being disputed, can you hold longer than 3 days if they are trying to get the other part within 5 days? Or do you return it within 3 days and just have them bring the entire amount back?
Great question.
That's a good one. So the big part is having the conversation with the tenant. The tenant knows that you're not accepting the money, and as long as the tenant has been notified and you have communication, I think you would be fine holding it for another couple of days, allowing them to either bring the rest in or sign a promissory note, rather than putting them at a disadvantage by mailing it back to them, and that delays it for everybody. So that's not the intention. The intention really, the issue has been not notifying the tenant that the money isn't being accepted. That's where you have a problem. When you end up filing a 5-day notice, going to court, bringing the money order to court, and saying, yeah, they dropped us off a while ago, but we're not taking it. If the tenant didn't know about it, thought their rent was paid in full, that's a disadvantage to the tenant, and you shouldn't do that. So if you're working with the tenant, absolutely, you can do that. It's still disputed funds. You still need to, you can't deal with it forever. You can't hold it for 60 days, but for a short amount of time, the judges have set a reasonable amount of time.
I can tell you that's typically going to be about 5 days. The statute's 33-1371, and what it says is if a landlord accepts a partial performance of a tenant, then they are not allowed to proceed with whatever that violation is. If you have the money in your safe and you say, I haven't accepted it, from the court's point of view, yes, you have, because it's in your control. So send the tenant an email or text saying, hey, I'm not able to take it. If I don't hear from you in 3 or 4 days, I'm going to send it back to you certified mail. You don't hear anything, send it back certified mail. If there's a game played where it keeps passing back and forth, at least get it out of your hands. And I would tell you not more than maybe 5 or 6 days, because most judges are going to say, if you have it more than a week, I'm just going to pretend like you got it and you kept it.
So are we talking calendar days or business days?
I'd say calendar days.
Okay, so
And I would also caution you to make sure that you do what you say you're going to do. If you get a partial payment and you send a letter to the tenant that says, if I don't hear from you in 3 days, I'm going to mail this back to you, mail it back to them. Don't hold it longer than that. Send it back to them. Do what you say you're going to do.
All right. Can we charge the tax to the tenant on late fees, and or would we have to add that to the lease?
So late fees are interesting. Each city is a little different, and there's some a little bit of fogginess regarding fees that go from the tenant to the property management company as to whether or not those are taxable. If you talk to some cities, they say, yes, absolutely they are. Other cities are whatever goes to the owner is taxable. So it's a little bit unclear. So we don't really know. I would say that if your owner gets any portion of the late fees, that is absolutely taxable. Some companies choose to split late fees with the owner or give all of the late fees to the owner. If the money goes to the owner, it's taxable, period. Your lease should say that. The AR lease says that. It says that all past due items will be considered rent, so rent is taxable. You're covered on that. Any amount of money that's going from the tenant to the owner, late fees, NSF fees, any other kind of fee is taxable. If it's going to the management company, that's a business decision. It's up to you as to whether you're going to tax that or not tax that. Talk to the cities, make sure that you're clear. But until they clearly define with every city exactly what is taxable and not, that's going to be a business decision. And take a look at the model city code as to what it says. It says the gross revenue or gross income from the business activity is taxable. It seems pretty clear that any money coming in from the tenant's taxable.
So this one goes back to the dates and having the dates match. So if an online payment is received on the 29th and entered into the accounting software on the 1st, okay, which could give you a couple of days difference, should you put the date entered as the 29th to match or leave it on the 1st?
So it depends on what you mean by received. Received for an online payment, most online payments are initiated, and then within 1 to 3 days, they actually hit your bank account. For online payments, I would highly suggest that whatever day it hits your bank account is the day you post it in your system. If somebody mails you a rent check on the 15th and you receive it on the 25th, you post it on the 15th when they mailed it or on the 25th when you got it. You should post it when it hits your bank. So that's what we're talking about as far as the dating issues go. Don't tell it went to the bank on one date when it really went to the bank on a different date. So for online payments, post those in your system the day that it actually hits your bank. When you reconcile your bank statement, those dates should match up perfectly and be the same dollar amounts.
So even though you've got advance notification that the funds are pending, you really want it to, you want to wait until.
Absolutely. So what if the tenant cancels it while it's processing? What if it bounces? What if they typed in the account number wrong on their online account or the routing number wrong and it never hits your bank? You should go based on when it hits your bank account.
And if you think about it, that's just like the tenant calling you and saying, hey, I'm mailing you the check. It's just the bank, the online system saying, hey, we're going to mail you a check. It's really the same thing if you think about it like that.
Excellent. Okay, and the last one is kind of FYI. It says, Sherry shares with us that Yuma just got notification that TPT tax is being enforced. It has not in the past. We noticed owners that are not collecting taxes and cannot get a clear answer from the city or ADR on how to comply other than noticing the owners. Any comments, thoughts?
Well, if you're notifying an owner that the state or the city requires a tax, it's the owner's obligation to pay the tax. Not all property managers collect the tax for the city because it's not their job unless they agree in their property management agreement. You don't have to collect that tax if you don't want to. I can tell you most of us do because we want our owners to be in compliance. And so if you've notified the owner, hey, heads up, they're now enforcing this, then so be it. If you haven't been collecting it from the tenant, then you should be. If you are on notice that the city is enforcing that, then you should be making sure that you're collecting it from the tenant. The problem might be that your lease doesn't say that. We've seen lots of leases in the last couple weeks that just says the rent is this amount, including tax, but it doesn't have a separation. If it didn't separate what the tax amount was, instead of the owner now making $1,000 a month, it's going to be $900 and something because you're going to back out the tax because you can't charge the increase if your lease didn't notify the tenant ahead of time that the current tax was this and it's subject to increase. So look at your lease. If you're using some kind of magic word that's not an AAR form lease, you might have a problem charging the tax at all. You still got to collect it, but you might have a problem charging the tenant till a renewal.
And Denise touched on that a little bit. That is a management decision as to whether you want to deal with taxes or not. You're not required to do that by the state. You can push that back to your owners, depending on what your management agreement says. If you agreed to do it, then you have to do it. But if your management agreement doesn't cover it, you can collect it, send it off to the owner, and the owner would be responsible to fill out the forms and pay that. That's a business decision as to whether you want to do that or not.
Excellent. And then just to reiterate, when somebody receives a payment and it's pending again, you want all the dates to correlate with the date the money actually hits your bank account.
That's correct.
Correct?
Yeah.
Okay. So I just wanted to say that. So even though the leases nor the management agreements say we charge tenant taxes, we have to collect tax and send to owners.
Let's make sure we're clear about that question. So if your lease does not say that the tenant has like $1,000 of rent plus whatever dollars in tax, the city still is requiring you to charge the tax. So that means you have to explain to the owner that the $1,000 you're sending him, however much that is, $2.64, whatever it is, that amount of money is actually the tax, and the owner has to send that tax money into the city. If your lease is not clear that there's a separation of tax, the owner is still required to pay that. So if the management company is collecting the rents, then either you're going to collect the rents and pay the tax on behalf of the owner, or you're going to collect the rents with that tax and send it to the owner and have him pay it. Either way, it's still going to be taxed, even if you haven't taxed the tenant, because you didn't write it correctly in your form.
And the owner is ultimately responsible for the tax. That's not the management. The only time you would be responsible is if you were paying it on behalf of the owner and you had math errors or calculated it improperly on the owner's behalf. You may have some liability, but the owner is ultimately responsible for the tax.
Excellent. Okay, and then folks, we just want to thank you so much for sticking with us for today's webinar. Just so much information for property management. And just to let you know that we do have the Certified Residential Property Management Program that we have rolled out in this last year. You can visit aaronline.com for more information. We have a ton of classes coming up. Denise, what's your next class coming up?
Next class coming up is, let's see, I think it's next week. I think we have one coming up. So we've got.
You have one next week doing the ins and outs of the AAR forms.
I believe that's accurate.
Excellent. And Mike, what about you? Where are you speaking?
Well, my next class is actually in Boise, Idaho, but my next one here, I'm doing trust accounting down in Tucson. I believe in April is my next class.
Excellent. And then, of course, Denise has an incredible website available with just a ton of information. It's drevictor.com. And if you've joined us in past for other webinars, you know that I will send out a follow-up email with all the links and everything that both Denise and Mike have mentioned today. And can we get a copy of the slideshow? Stephen, I don't typically send out the slides. However, today's webinar was recorded and will be available on our website within the next couple of days, so you can grab it from there. Thank you so much. If you have any questions, feel free to send them to us, and I will forward them on to Denise and Mike. Thank you again, everyone, and we hope you have a great day.